Hello everyone, I'm Audrey Wilson. I'm the Community Engagement Officer at the Scottish Council and Archives, and welcome to our fourth webinar in the series Next Steps. It's a follow-on from First Steps, Caring for Community Archives, which was part of a archive tour in 2019, delivering a one-day training event. Today is an information-packed 30 minutes webinar, which takes place every Monday morning. Today we hear from Gillian Mapstone, Head of Records and Archives Engagement at the National Records of Scotland. So today Jill is talking about data protection of community archives, especially important now that the UK has left the European Union. There may be a few changes in how we handle our records. So a little bit of notes about housekeeping. We are recording this session and I will send you the recording. It will also be available on the SCA website, and I'll post it on our Twitter page on @CArchivesScot. As an attendee, you can ask questions using the Q&A button at the top. I will be monitoring it throughout the presentation, but I'll be gathering up the questions and we can ask them at the end to Gillian if they're not answered during the presentation. Okay, without any more to do, I'll pass you on to Jill. Thanks.
Thanks, Audrey. Morning, everybody, and welcome to this session about community archives and data protection. I've got two caveats before I start this morning. One, I've developed a stinking horrible cold, obviously, when I'm now coming to talk to people. So if I cough and splutter, please excuse me. And secondly, the whole point of today is to explore some of the challenges around data protection in archives and community archives. But I am not a lawyer, obviously, so this isn't legal advice, but this is advice on the things to consider if you are a community archive group in relation to data protection. So if we could move on to the slide, please. I'm not going to give you a full history of data protection legislation, but it's really useful, I think, to understand the context of where we are at the moment, given the changes that have happened over the past few years. Data protection legislation predates the first piece of legislation on here, which is the 1998 Act, but I'm sort of starting there because that was the codifying piece of legislation that brought the UK in line with European partners. And most significantly, this is when data protection legislation changed from just covering computer-based records and extended into paper and manual filing systems. So it really did change at that point. After that, we then got the EU GDPR in 2018, which everyone will have heard of. That's the one that comes with the big fines. And then in 2018, the UK passed more legislation to sort of bring these two pieces of legislation together into one. And just as we were getting a handle on that, we left the EU, and this all had to change again. So with effect from the 1st of January this year, new legislation was passed in the UK to bring together all this data protection legislation into one piece of legislation that works in the UK context post-Brexit. And that is now known as the UK GDPR. So I hope that's as clear as mud, but it's just useful to have that background. If we could move on to the next slide, please. Data protection legislation in the UK GDPR that aims to protect individuals' fundamental rights and freedoms in an increasingly data-driven world. So it's important to look here at what that law applies to. Personal data is information about living individuals, which can be held in the records of any archive and indeed any organisation. It's digital information, but it also includes some manual paper records too. And it's important that there's rights and responsibilities that are set out for all the people who have a connection to the information. One of the big changes that came around with GDPR was the need, however, that organisations keep data only for very explicit purposes and only for the length of time that they were using it for that purpose. And this caused a challenge for archivists because obviously we retain records that have an enduring value beyond the purpose for which it was first collected. So the UK GDPR, which is now in place, recognises that there is a public interest in permitting this permanent preservation, and there's specific provision in it for archiving purposes in the public interest. But what I would just like to sort of pull out there very explicitly, that phrase archiving in the public interest, that doesn't mean you need to be a publicly funded archive. It's about the interest of the general public rather than it being an organisation or a state-controlled thing. So archiving in the public interest does extend to voluntary organisations, community heritage groups such as yourselves. Next slide, please. These are just some key terms that you're probably all familiar with, but it's worth again just being very explicit about this. Personal data can be recorded in any form or format. So it can be websites, digitised images, emails, paper records, registers, anything that identifies a living individual. And it might not be that it names the person, but from information in the record, you can identify who that person is. And then you have special category data. This used to be known as sensitive personal data. This is personal data that has a special dimension to it that can reveal more about the person. And special category data has to be managed in different ways to just standard personal data. And that's something to bear in mind as well. And as I mentioned already, there's different and explicit roles and responsibilities in the legislation, depending on how you interact with the data. The data subject is the term for the person who is in the information, who the information is about. The data controller is the organisation that has collected or manages that data. And a data processor can be anybody that does anything with that data. And each of these people have different rights and responsibilities under the legislation. I won't go on at length at this because all this information is much better explained by lots of other guidance out there, particularly on the Information Commissioner's website. But it is really important that people feel confident about these different terms when thinking about data protection. Next slide, please. So I mentioned archiving in the public interest, and again, I won't go through all of these things, all these slides will be made available, but it is permissible to retain information for longer than the reason it was first created if it is going to be used in some of these ways. And so archiving purposes can include the acquisition and selection of records, the storage and preservation, the description and the provision of access for research. So personal data may be stored for longer periods insofar as the personal data will be processed solely for the purpose of archiving in the public interest. Next slide, please. So this is a familiar image, and we're all probably very familiar with what this sort of relates to in this context. There was concern when legislation changed that the records had to be kept only for a very short amount of time, and this came to a very public light when we had the information that was collected by the Home Office when immigrants arrived in the UK and their landing cards, and these, when required for identification purposes some decades later, had been destroyed and caused significant distress to the individuals who've been featured in it and difficulties for public administration. This had been a very over-cautious interpretation of what was required by data protection, and there clearly was a public interest in the retention of these records for historical purposes and for accountability purposes. So this is just me kind of highlighting that this doesn't have to happen, and UK GDPR is not in place to prevent people from archiving and doing that properly. And the very last bit of that quote there, I'll just read that aloud, is the law contains the necessary safeguards to permit archiving. And you should feel confident about that, as long as you are taking the correct measures, which we'll come on to talk about in a wee second. You are perfectly legitimate in retaining records for archival purposes in the public interest. So if you take nothing else away from today, that's the key message. Next slide, please. This is just really a bit of a silly slide that shows that a very overzealous interpretation of the legislation would put Santa out of work. And like Santa, the legislators for this are not trying to put Santa or community archivists or any archivists out of work, as long as the steps are taken to balance the rights of all the individuals in the data. It's worth distinguishing between the two types of personal data that community archivists will come into contact with. And that is the personal data that's in your archive collections, for example, letters or documents, photographs relating to living individuals. And then there's the personal data that you collect as part of the process of running a small organisation, such as mailing list names, event bookings, membership lists, correspondence, inquiries. So these two things are things that community archivists and heritage groups need to be considering. In terms of the personal data, which is part of the archive, this can be things like school logbooks, church registers, community event photographs. There's lots of guidance available, and I think Audrey sent these out towards the end of last week, a lot of links. And I wouldn't be able to give you any more information that's available from these sources. But what I would say is the guidance which has been drafted by the National Archives in England is really helpful and is a sort of step-by-step guide to what you should be thinking about when you are processing archival materials. In addition to that guidance, on their website they also have an FAQ page, and as case law develops in this space, they update that and make that available. So I would really recommend looking at that. But again, what I would say is you do not need to destroy or return any archival information that contains personal data about living people. You just need to take the steps and appropriate steps to ensure that that information is managed properly, securely, that you're transparent in how you do that. As I say, that's all touched on in that guidance, and I would recommend that you look at that. Current laws around privacy and defamation already make it unwise for information to be published about living individuals. So it's unlikely to cause much difference in your current practice. If you were compliant with data protection before we left the EU, most likely you are compliant with it now in relation to your archive. But have a look at that guidance, it is really useful. So the second area is the personal data that is collected for the purpose of running your heritage group or your community archive group. And there's certain things that you should be thinking about in terms of your responsibilities with that information. It's important to, as a first point, a starting point, carry out an audit of the personal data that you hold. Look through your website and any other records that you have, and itemize, audit what information you collect and how you store that personal data. For each of the type of personal data you hold, give some consideration to whether you actually need that information. Do you need that level of information? Think also about how long you should keep it for, whether you need to update the process by which you collect it in terms of the forms you use so that it's clear exactly what you're doing with that, and how you can make it possible for individuals to ask about what data you hold about them and how they can get copies of it or have it removed. Delete unnecessary personal data. Going from your first point of your data audit, once you've identified all those different types of data that you hold, get rid of the stuff that you don't need. For example, people who've attended past conferences, when they attended that, they gave you their personal data in order to be part of that event. You can't then go on and use that for other things, and that's an important thing to think about. Provide a method by which people can find out what information you hold about them. So perhaps have a link or a form on your website or a contact address where people can know they can ask you, what information do you have about me? And there's a method by which you can provide that back to them. And update your privacy page. The Information Commissioner's, privacy statement, sorry. The Information Commissioner's Office have got really good examples and bad examples as well, just so you know what not to do, of good and bad privacy notices that is scalable to lots of different organisations. That's on their website, and I think we gave a link to that, but if we're not, it can always be provided. So yeah, have a think about the data that you manage as a group separately to the data that you're holding in your collections, because you need to think about these things in different ways. Next slide, please. Catalogues and finding aids are a particular challenge for all archivists in terms of personal data. Obviously, archives and records are full of names, and you need to give some real consideration to how you describe that information and that process of describing whether it's appropriate to include personal identifying information in that, specifically names. So when doing that, give consideration to these things. Is the person alive or dead? Well, if they're dead, that's fine. You don't need to consider anything else in relation to data protection. Is the person identifiable from your description of a record? And if they are, give consideration to whether or not it's really necessary to identify a person when describing that record, or is there a different way to describe it? Is the information already in the public domain? That's a key consideration, because if it's a matter of public information and people know about this as a fact, then you including names and information in your catalogues and finding is less of a significant thing. And crucially as well, is it likely to cause the person substantial damage or distress? If this is the case, then you really must consider whether it's appropriate to be creating a catalogue or a finding aid, which you're then making publicly available, if that very act is going to cause somebody damage and distress. And if it is, I would caution against using that. Another sort of thing to consider as well is the age of the record, and whether the information could be made to be open or closed. If the record contains information about an adult, generally as a rule of thumb, if it's very sensitive special category data that's not already in the public domain, we would recommend closing that information and its description for up to 75 years. And if it's a child, we recommend that for 100 years. But that you can open records for before that period, but you have to take particular steps to do that, which we'll come on to again in a wee second. Next slide, please. Photographic images of individuals and small groups are defined as personal data, and so they do fall under the scope of the Data Protection Act. So care is required with photographs, even if a photograph is anonymous in the sense that, well, like this one, it's not captioned with names nor tagged with names in the metadata, but it's still possible that an individual could be identified. In all cases, the likely effect on people of their image being made available must be taken into account. Bear in mind as well that photographs often depict special categories of personal data. So perhaps people undergoing medical treatment, someone being arrested or taking part in a demonstration. Where individuals are incidentally included in an image or they're not the focus, then it's unlikely that that can be considered to be containing personal data. And there are exemptions for this. It's very difficult to provide a general ruling in the context of photographic personal data. And again, it's really a case-by-case assessment of what is the nature of that information and what would be the impact of disclosing that on the person who is featured in the information. It's crucial in this context that every group consider having a takedown policy statement somewhere on your website, which says that if you've got an image up there, someone can contact you, they can ask for it to be removed, and you will do that. Things can be done in good faith and may go slightly wrong, but if you have the mechanisms by which someone can contact you and you can address that problem, then you are complying with data protection legislation. Next slide, please. Public use of archived personal data will generally be possible once the people in the data are dead, but it may be possible earlier than that if the use is fair to the individuals in the records. There's a link on this slide, but I know it was sent out last week, to something that we use at the National Records of Scotland, which is personal data research agreement, and we ask all our researchers who access any of our records to sign this to undertake that they will comply with their obligations under the data protection laws. And any community and heritage archive group can do that too. So it is possible to make to living individuals available for research purposes, but you just have to put safeguards like this in place and be clear about the responsibilities that somebody is undertaking when accessing that information. Next slide, please. And yeah, so this is the final slide actually. So this again is just to say there is a lot of resource out there. A lot of work has been done in this area, and it is applicable to community archives groups. I would recommend looking at this guidance. It's very rare that I say the European Archive Group develop really clear guidance, but they did in the context of data protection, and it is still very much applicable to what we do in the archive sector through all the different processes associated with this. So I would just recommend having a look at these things. But as it says there, keep calm. You were probably doing it if you were doing it right before, you're most probably doing it right now. There's just some things that you need to give some consideration to ensure your continued compliance. And that is the end of my section of this event in terms of a presentation. I think, Audrey, we're going to maybe have some questions and a bit of a discussion, I think.
Yes, I'm back now. So I got lots of very interesting questions during the Q&A. If you're having problems with the connection, this is the people attending, please turn off the videos for the speakers because that might help as well, and we might sound better. I think it's that Monday morning. I think someone said Monday morning's a bad time, isn't it, when you're online? But anyway, I want to crack on here, actually, Jill. We've got some great questions, and one I'm just looking at from Amanda Mackey, and it says, I wonder when the Windrush records were destroyed, our council is shocking at throwing out important archives.
Yeah, that is, I'm not sure, I couldn't speak to when the Windrush records were actually physically destroyed, but I do know that this has been a real concern over recent years with the arrival of GDPR, because this was trailed along with balancing what was a new thing then, the right to be forgotten. And we hear about this a lot, about the right to be forgotten and people's right to be forgotten. However, archivists of all descriptions, of all guises, they have a right they have a duty to document as well. And records that have an enduring historical value that are made available for research, academic, statistical, accountability purposes, there's a clear responsibility on archiving in the public interest. And so this overzealous interpretation can lead to data destruction, and it is a concern and it is a worry. The thing that I've said before, the big takeaway from today is the law permits archiving in the public interest. So consideration about, yes, the security and the protection and the fair processing of personal data, and the special category personal data especially, but it is allowed and it is permissible. So if somebody's suggesting to you, you should destroy this because of data protection, that would raise alarm bells for me. And there's no need for that. The provisions and safeguards are there. We see it now, actually. We're currently going through the Scottish National Child Abuse Inquiry, where the preservation of historic records is essential to public accountability. So it's definitely within the legislation, and it's not the purpose of the Act to stop that from happening.
Yeah, sort of following on from that, actually, it's something's coming from Jill Fewings, hope I've pronounced that correctly. It's getting people to pass on information she's finding is quite difficult if they don't understand GDPR. They think they have to destroy everything. And so as an archivist, you don't get anything to start with. What's your advice on that for people? Again,
my advice would be have a look at those archive-specific guidance documents from the National Archives and from the European Archive Group about the things that as archivists we can do to reassure people, by being explicit with engaging with a record creator and being explicit with them about how safe it is and how appropriate and legal it is to retain information, and indeed how important it is to retain information for archiving purposes, so that you feel confident when you're talking to them and they are assured. Unfortunately, if they've already destroyed it, then that's, there's no way back from that. But certainly that's about engaging and making those record creators feel confident that they are complying with the legislation, and they are.
Okay, so just following on very briefly actually with that, Jill, so info in the public domain, you talked about that in your presentation. Does that include members' magazines? Because there could be lots of copies and you could find them on eBay, Gumtree and all of these things online. Does that count as public domain?
So if something's been published, then it's accepted as being published into the public domain. It's difficult because it depends on how many people saw it originally. There's actually no clear-cut guidance about what is meant by the public domain, helpfully. But if you imagine that something that's reported on in a national newspaper that's been exposed to a wide audience, we can accept that that's in the public domain. If something was just published in to a small audience, it's less over time, it's less likely to have any public knowledge of that event. So it is about weighing up all these different circumstances, unfortunately. Great.
I'm just going to ask another question. I want to say Sue Bush has very kindly come in here and said Windrush destroyed 2010, just to let you know, so everyone. Okay. A few questions here about photographs and Instagram and things like that. So we've got from E. Ritchie, we have a 60-year-old local school photo posted on Instagram and Facebook recently. Enthusiastic response from followers. No adverse comments were made, but should I amend the post to say to contact us if anyone wishes to have the post removed?
Yes, absolutely. That is a really good example. So a school photograph does contain identifying information. You can identify the individuals in it. They are alive. That is personal data. Now, generally, the disclosure of that isn't likely to cause somebody damage or distress. However, it is processing of that personal data. So the sensible and responsible thing to do would be to have a mechanism whereby anybody who comes across that who thinks, I don't want my image up there, I had a really bad hair day for that school photo, can get in contact with you and say, I would like that removed, and that you act appropriately to respond to that, because it is their personal data and you are processing it by making it available in that way.
Great. Yes, we've had a few questions about that, about putting images onto a Facebook page and things like that. I'm just running through because if I have missed anything.
Yeah, it is fine to do that. It is fine to do that, but it's just about having the mechanism there by which people can contact you to ask for that to be removed, and then responding appropriately to that. But it is okay to continue to do that.
Okay, that's great. Listen, I'm not seeing any more questions that are different from that. And what I've also said, Jill, and I hope you agree with this, is if people do have any questions they can think of, they can actually contact the National Records of Scotland using the email address that's on your slides. I will put that out again as a reminder when I send you a recording of the webinar today. I'm also going to send everyone a short survey. So if we can get your feedback, it's really good. So then we can provide more training events like this. If you do answer the feedback form, that is brilliant. But I am just checking.
What I would say as well, Audrey, sorry. No, what I would say is, by all means, do contact the National Records of Scotland, because we have a small team of people who deal with this stuff day in, day out. But also, contact your own network of people. You know best about the types of records that you hold, and other people who do similar things to you might have already developed a privacy statement, or they've done an audit of their data collection, and that's always useful to talk to your peers and learn from each other. And in addition to that, bother your local archivist. Scottish local authorities have all got wonderful archivists who also deal with this a lot, and they are more than happy to connect with you and help support the work you do. So take advantage of them.
Yes. On that note, we've hit 11 o'clock. Time now to put your coffee down and get back to work. But I want to just say a big thank you to Jill today. Lots of information and lots of people coming back, Jill, saying thank you very, very much. It was a really good session.
It's my pleasure.
So thanks everyone for coming, and we'll see you next Monday. Bye.
Bye.
Bye.